I don't know. I can't.
The answer is it has not. And do you know why we know that? Because it was incorporated 8 days before this contract went out. You want the American people to believe that this is all above board?
Yes,
that $143 million of taxpayer money just happened to go to this one company that doesn't have a headquarters, doesn't have a website, has never done work for the federal government before, and is registered, apparently, or attached to a residence from a political operative. And of course, one of the subcontractors of that contract, as you know, is a political firm that's tied to you back when you were governor of South Dakota.
$220 million. That is the precise amount of taxpayer money the Department of Homeland Security distributed through an advertising campaign. $143 million of those dollars went to a single company. That company did not exist until 8 days before the contract was awarded. A cabinet secretary then sat before the United States Senate and swore under oath that the process was competitive. That statement is false. It is documented, and the paperwork proving it false was filed by her own agency. Kristi Noem, the Secretary of the Department of Homeland Security, controls billions in federal funding. She holds some of the most consequential executive authority in the current administration. When she appeared before the Senate and was directly questioned about this $220 million contract, she made one specific, verifiable claim. She stated, quote, "It went out to a competitive bid." Representative Joe Neguse of Colorado, a member of the congressional oversight apparatus, immediately confronted her with the exact language of that quote.
Now, yesterday, you testified, I think I'm quoting you right, you said, quote, or in reference to this contract, that, quote, "it went out to a competitive bid." Do you stand by that statement?
It was a no-bid contract where two vendors were
It was a no-bid
chosen.
contract.
If it would have been a no-bid contract, if I'm using that correctly, it goes out to two different vendors.
Correct. So it was
There
not a
many
competitive.
media
Let me try to explain
agency.
what the discrepancy, because a competitive bid is very different than a no competitive bid, and I'll just explain why.
The discrepancy is not subtle. A competitive bid means companies across the country submit proposals and the best offer wins. A no-bid contract means the government selects a vendor without that process. Secretary Noem told the Senate one thing. Her agency filed paperwork confirming the opposite. The paperwork in question is titled Justification and Approval for Other Than Full and Open Competition. That document was filed by the Department of Homeland Security.
You know that your testimony yesterday, when you said, again, I'll quote, "it went out to a competitive bid," is untrue. The reason we know it's untrue is because under federal law, your agency is required, whenever the agency decides to skip competitive bidding, to file a notice with the public explaining why. And in this case,
Right.
your agency filed a notice.
Right.
You're aware of that,
Right.
right? Justification and approval for other than full and open competition. Your agency made a decision not to proceed with competitive bidding.
It exists. It is part of the public record. In that document, the agency explicitly stated it was not pursuing open competition. Instead, out of hundreds of thousands of companies operating in the United States, the agency identified exactly 4 candidates. Safe America Media was one of them. Safe America Media then received $143 million. Representative Neguse then laid out what Safe America Media actually is.
So that is why the two of them were
That's
chosen.
inaccurate, Madam Secretary. I'll read from the notice from your agency. Given the immediate action to significantly reduce illegal immigration and border crossings, DHS identified 4 companies. 4 of the hundreds of thousands of companies in the United States, you identified 4. One of those is this Safe America Media company. Where is Safe America Media headquartered?
I don't know.
I don't know either, Madam Secretary. We can't find it. We can't find a website. We did find an address that's registered for this company. Do you know where that address is?
Is there a problem with this contract?
I'll
Because
tell you
was
about
done
it.
According to
Madam
law.
It has no functioning website. It has no established headquarters. It has no prior history of performing any work for the federal government. Its corporate registration traces back to a residential address in Virginia. That residence belongs to a political operative. That operative carries documented affiliations with a former political director of the National Republican Congressional Committee. There is also a subcontractor embedded in this deal. That subcontractor is a political consulting firm directly tied to Noem's tenure as governor of South Dakota. The same political network she built at the state level appears inside a federal contract worth $143 million. Senator Tillis, on the Senate floor, established a separate and critical fact. The Department of Homeland Security is currently blocking the Inspector General from 11 distinct active investigations. The Inspector General is the independent watchdog designed specifically to prevent this category of fraud, waste, and abuse. He is not being allowed to proceed. Representative Neguse confirmed the forensic timeline. Senator Tillis confirmed the obstruction. Two separate institutional authorities operating through separate chambers of Congress are pointing at the same building and describing the same wall. Secretary Noem has offered a defense. It rests on two arguments. The first is effectiveness. She claims the campaign generated 14 billion impressions. She argues it produced results visible in self-deportation data. She defends the geographic spread of the spending, noting it reached 8 countries where illegal migration originates. Her position is that the outcome justifies the method. The second defense is procedural. She states the Inspector General has been told he may access anything.
And ultimately, I think there's going to be accountability. And I yield back, Bill.
Can I speak to the IG?
Yes, you can. Quick.
The IG has been told repeatedly, in writing, verbally, on the phone, that he can have access to anything at the Department of Homeland Security. He can. He doesn't need my permission to come and brief members of Congress on the Hill. He just needs to provide a scoping memo, which is what every single IG gets from every single department and agency. All intelligence agencies require a scoping memo. He just hasn't done that. He wants unfettered access to every single thing in the department, and that's not the process, and that's not any other IG has demanded that.
Neither defense holds. Generating 14 billion impressions does not retroactively legalize a fraudulent procurement structure. Performance metrics do not override federal contracting law. The law requires open competition unless a documented specific emergency proves only a particular vendor can respond. Safe America Media was incorporated 8 days before the award. A company with no history, no infrastructure, and no demonstrated capacity cannot be the answer to an immediate national crisis. That is not how emergency contracting works under any reading of federal procurement rules. And demanding a scoping memo from the Inspector General while simultaneously blocking 11 investigations is not standard protocol. It is administrative delay applied at scale. The paperwork blocking oversight has the same effect regardless of what it is called. 3 legal concepts define what is at stake. The first is federal procurement law. When the government spends public money, competition is the legal default. It prevents corruption and controls cost. The justification to skip that competition must be narrow and documented. Awarding $143 million to an 8-day-old company with a residential mailing address does not meet that standard under any reasonable interpretation. The second is conflict of interest. Federal officials are prohibited from directing public money toward their political networks. A subcontractor tied to the secretary's own political history is not a coincidence. It is a financial connection that carries legal exposure. The third is false statements to Congress. Under federal law, making a materially false statement to a congressional body is a crime. The statement that this contract went through competitive bidding, made under oath, directly contradicts the agency's own filed documentation. That is not a misremembering, it is a contradiction that cannot exist honestly. The weight of this record carries its own conclusion. A newly formed company with no operational history received $143 million federal dollars. The contracting agency documented its choice to avoid open competition. The secretary testified to the opposite under oath. A political subcontractor from her own gubernatorial network appears inside the deal. The Inspector General is blocked from 11 investigations. No credible innocent explanation reconciles all of these facts simultaneously. The evidence does not require emotional amplification. It stands on its own procedural and forensic weight. The institutional response has been inadequate. The Department of Justice has not moved. The agency continues to obstruct oversight through administrative mechanisms. The Inspector General cannot brief Congress freely. The mechanisms that exist specifically to catch this category of misconduct are either blocked or silent. The failure is not incidental. Every layer of oversight that should have activated has instead been held in place. The procedural path forward is narrow and slow. Congressional subpoenas can compel documentation. The Inspector General can sue for access if administrative obstruction continues. A Department of Justice investigation, if activated, would move toward a grand jury examination of federal procurement fraud and false statements. The financial audit, if permitted, would map the full routing of the $220 million. Members of Congress are signaling they will move to restrict further Department of Homeland Security funding until the 11 blocked investigations are allowed to proceed. These are the available mechanisms. They are not fast, they are not guaranteed, but they are the remaining procedural structure inside which accountability, if it comes, must travel. The money has already moved. The contract has already been paid. What remains is the record, the oversight fight, and the legal exposure of a sworn statement that the public record contradicts. Before we close, one quick clarification. This script is based entirely on publicly available congressional testimony, official federal procurement documents, and verified reporting from the public record. It does not constitute legal advice, and it is not a call to action of any kind. Reasonable people examining the same documented facts may reach different interpretations regarding intent, culpability, or legal consequence. The analysis presented here represents one structured reading of the available evidence. We encourage thoughtful, evidence-based discussion in the comments below. If this kind of disciplined investigative breakdown is valuable to you, subscribing ensures you do not miss the next one.